Is Potify confusable with Spotify? Hi, I'm Jason Rosenblum. I'm an intellectual property attorney. I protect my clients' products, brands, and businesses from getting ripped off. And in this case, I just wanted to talk about Potify, which was a trademark application that was recently opposed by Spotify, and Spotify ultimately won. But here's their website, potify.net. So they filed for downloadable software for use in searching, creating, and making compilations, rankings, reviews, recommendations relating to medical marijuana dispensaries and doctors' offices. Then they have for clothing items, and then they have for providing information related to medical marijuana, providing a website featuring ratings, reviews, and recommendations, and then computer services for creating an online community, for registered participation, feedback, da 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 da. So this application actually went through with very minor issues, and it even was approved for publication. But then what happened was Spotify came along and opposed it. So if you look at those services, they're not the same. Spotify plays music, and Potify is all about medical marijuana. So except for the fact that people might listen to music while they're taking their medical marijuana, there's no real relation there. However, when you have a very famous mark such as Spotify or Nike or Google or Apple, you actually have more protection than you would with just a regular trademark. So, although the examining attorney did not cite it against Spotify took it upon themselves by filing what's called an opposition action against Potify. And this is the decision by the Trademark Trial and Appeal Board, which is an administrative body at the U.S. Patent and Trademark Office, and basically looked at all the evidence, looked at all the factors you look at. And in this case, one of the main things they looked at is what we call dilution. And that's when you have a famous brand, something like, as I said, Spotify, Apple, Microsoft. Those brands are so well known and are in so many different areas that they get more protection than just a regular registered trademark. And basically, the Trademark Trial and Appeal Board, after looking at all the evidence, looking at all the arguments, they said that there's no question that Spotify is a famous mark, that Spotify goods and services are widely used and recognized by a large percentage of the US population, or that opposers' Spotify mark is highly distinctive. Um, Basically, what they're saying there is so many people know about Spotify. The mark itself is so unique, and it doesn't describe the type of service that you're providing. It's essentially a made-up name, has nothing to do with providing a website to listen to music for streaming. And they said that this was the case prior to applicants' claim, that they have prior use of their mark. The registration was before Potify. That there is likelihood that there will be some dilution of Spotify, meaning that people will not necessarily get confused, but it will just diminish the value and the brand awareness of Spotify by allowing someone to register a Potify. So they denied the registration. What that means now is that what that means for Potify now is that they don't get a registration. However, what Spotify can do now is take that and go to federal court and potentially use that to make their case much easier to say that Potify is an infringer and that Potify is diluting their brand and seek remedies that way. So, there's always concerns when you're filing a trademark that you're going to put someone, I don't know how big this Potify company is, but, and here's their website. But when you file a trademark, it's public. And what happens now is even though you can get past the examining attorney, as they did in this case, the larger company with a similar trademark or that believes their mark is going to be diluted usually has a watch service and can see that you filed, that it was approved, and can go after you by filing an opposition, because there's a much lower cost to them to file and maintain an opposition action against you than having to actually go straight to federal court and sue you there. So this is why I always say a search is key, and it's not just doing a basic knockout search. It's really doing proper search to see what's out there, and considering all these possibilities. I'm guessing Spotify is, if they're not maybe potentially in talks already with Potify to get them to cease use, or do something to limit any potential dilution, is that next you're going to see Spotify file federal court action uh, to seek an injunction and damages against Potify. If you like this, go down below and subscribe to the channel, and always feel free to reach out with any questions. We're at 888-666-0062. Thanks a lot.